Did you say we are live? Hello, hello, hello. Good afternoon once again. This is Dr. Olu Asekun here. Thank you for joining us. Our podcast is every Wednesday, 12 p.m. Central Standard Time. That is currently 1 p.m. Eastern Time. And that is currently 10 a.m. Pacific and 6 p.m. Nigerian time. Thank you for joining us again. Remember to invite your family, friends, and colleagues so that they can share part of this valuable information. Today, we are discussing the differences or the benefits of filing I-130 petition and K visa, that is fiancé visa, which is better for a U.S. citizen to file a fiancé visa or to file I-130 petition, relative petition. That is a topic we are discussing today. I'm sure it's going to be a very interesting topic because this is a question we receive at our office on regular basis, almost on weekly basis. I'm not sure there has been any week that we don't receive this type of question. Oh, I have a fiancé out of the country. I want to bring my fiancé into the country. Is it better to marry and petition for my fiancé, or is it better to bring in my fiancé in as a fiancé? So we receive this question all the time, and that is why we decided to address it today in today's podcast. Now, bringing a partner in as a fiancé is different from bringing a partner in as a spouse. Each of them have their separate advantages and disadvantages. And those are the issues that we are going to be discussing today. Generally, immigration is not a one-cap-fits-all. Every situation is different. As a fiancé is faster. In some cases, that may be the case, but in most cases, it is not. So there are so many things that we need to know, and we have to take so many things into consideration in determining which one to do. How can I? Just a minute. Please have a look at this. Someone is calling me and is intervening. Look at this number, this name. Please help me forward this link to that person. You can do it on WhatsApp. Sorry about that. Somebody was calling my phone and it was interrupting with what I was saying. So the point I'm making is that in determining whether to go for fiancé visa or whether to go for a spousal petition, so many things have to be taken into consideration. In some cases, it is better to file a fiancé visa, whereas in some other situations, it is better to go for fiancé visa. So which one is better depends on the particular situation of the applicant or the petitioner. But each one of them have their benefits and, of course, maybe what I consider disadvantages. And I'm going to run through some of them before we start entertaining questions. First and foremost, thank you. First and foremost, I need to go back to if we file a fiancé visa, the first thing we need to know that for a fiancé visa, it is a non-immigrant visa. And like every non-immigrant visa, it can be denied. And if it is denied, there is no room for appeal. Fiancé visa is a non-immigrant visa. That is the first consideration that we need to understand. And if a fiancé visa is denied, because there is no room for appeal, the applicant or the petitioner will have to start the process all over again, meaning that the petitioner will now have to go, and the applicant may actually succeed in extending or prolonging the time, even for years, if you embark on an unsuccessful fiancé visa application. So that is one of the dangers of going through a fiancé. Secondly, and most importantly, it is important that when you file a fiancé visa, the petitioner has an advantage over the beneficiary. Advantage in that if someone entered the United States as a fiancé of a US citizen, that person is stuck to that petitioner. You cannot marry any other person in the United States. If you do, you cannot get green card in this country. That is the law. Unless the Congress amend the law, that is still the law as of today. So, let me explain it further. If Mr. A has a fiancée, Miss B, and Mr. A decide to bring Miss B into the US as a fiancé, Miss B can only get green card in the United States only through Mr. A. If Miss B failed to marry Mr. A or married and divorced Mr. A, Miss B cannot get green card in the United States. Miss B will have to go back to her home country. So that is how dangerous a fiancé visa is. But of course, that is assuming that the relationship does not work. Where the relationship works, that will not be an issue. But where there is a failure in the relationship, the beneficiary is going to be at a disadvantage. So sometimes it may be better to be a little patient and go through the spousal route than to go through a fiancé route, and then you get here, there is a problem in the marriage, and you are stopped. So that is one of the major disadvantages against a fiancé visa. In addition, a lot of people assume that fiancé visa is faster. Well, this is debatable. Debatable in that generally, when a fiancé visa is filed, the petitioner will have to file from I-129, I-129F, that is fiancé visa application. That application has to be filed through the USCIS. In the same way, for people who are married and you are filing a petition, the petition, I-130 petition, has to be filed through USCIS. Both of these applications, they probably have similar processing time. Please, can you just help me confirm the processing time for I-130, US citizen petitioning for spouse, and the processing time for I-129F? Now, both of these petitions, they probably have the same similar processing time. So technically, you are not saving any time. Now, upon the approval of the petition, either I-130 or I-129F, the approval is forwarded to the National Visa Center under the Department of State. Now, at the National Visa Center stage, if the relative petition, the I-130 petition, is what was filed, the applicant only needs to submit application for immigrant visa, and then pay all the fees, get all the fingerprinting, and submit all the relevant documentation. In the case of fiancé visa, the approval will still be forwarded to National Visa Center. However, the National Visa Center will forward it to the US Embassy, and the applicant will need to apply for a visa at the US Embassy. Again, because this is an immigrant, because this is a fiancé visa, the applicant will still have to go through the preliminary things, including fingerprinting, including medical examination. The applicant is not going to skip any of this process. They still have to go through all of that. So technically, the only thing that the applicant is saving is probably the few months that those applications will have been submitted with the Department of State, National Visa Center, if an I-130 petition is being processed. So at the end of the day, why risk all those periods? Let's say, what is the processing time? Have you confirmed it?
Yeah, for fiancé visa, it is anywhere from 8.5 to 16 months,
Okay.
depending on the
Service center, okay.
For the I-130 is 14 months.
You see, for the fiancé visa, we just confirmed the processing time is any time between 8.5 months to 16 months. And now for the I-130 petition,
14.
it is the processing time is 14 months. So what is the difference? Because for fiancé visa, even though it says 8.5 to 16, it depends on the service center where the case is allocated. And as lawyers, we don't have control over the service center where cases are allocated. Service centers are not allocated based on the state where the petition is filed. You can file a petition in Texas and they can allocate it to National Benefit Center in Missouri. They can allocate it to Nebraska Service Center. They can allocate it to Vermont Service Center. They can allocate it to California. So it is not certain that the fact you file it from Texas is going to go to Texas Service Center. No, that's not the way it works, because there are only 6 service centers and there are 50 states in the United States. So that tells you that this is not a state matter. So at the end of the day, if your case is allocated to a service center where fiancé visa takes about 16 months to process, whereas if your case is allocated to a service center where the I-130 petition takes 14 months to at the end of the day, which one is faster? So that time you think that you are saving, technically you may not save it, because at the end of the day, if your application waited, let's say on the average, if you average 8.5 and 16, let's say it's about 12 months. If your application waited 12 months, from after the approval, you have to wait about 30 days for the application to be forwarded to the National Visa Center. That's taking it to 13 months. After that, between the National Visa Center forwarding it to the U.S. Embassy, with the U.S. Embassy giving you information on where to do the medical examination, with you providing. So let's say another 3 to 4 months. So at the end of the day, if you add that to 13 months, you are already going close to 20 months. So if at the end of the day, they don't approve it, because like I said, for as long as it's a fiancé visa, it's still a non-immigrant visa, which can be denied if the embassy have any. One of the major reasons why fiancé visas are denied. In Nigeria, for example, there are 6 types of marriages that are recognized under Nigerian law. And a lot of people don't pay attention to this. So somebody may be classified as a fiancé, whereas this person is actually married. But the person may not know and then apply for a fiancé visa, and in the process of submitting evidence of fiancé, the embassy may determine that, oh, this person is actually married, and then they will deny the application. I said, using Nigeria as a case study, there are 6 types of marriages recognized under Nigerian law that are valid, and the embassy know it. U.S. Embassy is aware of all of this. Number 1, there is what is called a marriage under the Act. Marriage under the Act is when 2 people elected to be married under English law. That means you both go to the registry and go and get married. So that is a valid marriage under Nigerian law. So it is called marriage under the Act. Is a valid marriage. The second type of marriage under Nigerian law is what we call traditional marriage or customary marriage. Customary marriage is common in the southern part of Nigeria, but it is a valid marriage. Customary marriage is when two people come together, when two families come together and they introduce each other. They introduce their family members to each other. In the southern part of Nigeria, in the southwest, it is called introduction and engagement. But it is a customary marriage is generally recognized in the south, including the east of Nigeria. Once two families come together in respect of two of their children and have conversation about marrying their daughter to a particular family, it is a valid marriage under Nigerian law. The third type of marriage recognized under Nigerian law is what is called Nikai marriage. This is a Muslim marriage. For Muslims, they conduct what is called Nikai. So it is a valid marriage under Nigerian law. The next type of marriage that is recognized under Nigerian law is what is called church marriage. Now, for Christians, they can organize a marriage and then the priest will join the couple together in matrimony. It is a valid marriage under the Nigerian law. Now, the next type of marriage that is recognized by Nigerian law is what is called common law marriage. Common law marriage does not involve any kind of ceremony. Once two adults, at least some, for as long as none of them is underage, two adults, once they come together and start living together and they represent themselves to people, to family, to friends, to colleagues as married, if all you did was just living together, and then when somebody is talking to the man, he's saying, "Oh, greetings to your wife," or "Where is your wife?" Or they are talking to the woman, they are referring to you as the husband. It is a valid marriage under Nigerian law. It is called common law marriage. Even in America here, it is a valid marriage. At least I'm certain that in Texas, common law marriage is a valid marriage. In fact, in Texas, they do issue marriage certificate for common law marriage to tell you how valid it is. And as an attorney, I've used common law marriage several times to get immigration benefit for clients. So it is a valid marriage, both in the US and even in Nigeria. So using that example. So when you look at all of those things, people who have been living together, even though they have not conducted any ceremony, so in their mind, they may be thinking, "Oh, we are not married. This person is still my fiancé." If you present evidence to the embassy in an attempt to get the fiancé visa approved, if you present evidence that suggests that any of these 5 things have occurred, then they see it as married, that you are married. So it means you are no longer eligible for fiancé visa. So they will go ahead and deny your fiancé visa. So at the end of the day, if the visa is denied, you start the process all over again. Because now, if the embassy tells you that, "Oh, we don't believe this person is your fiancé," in actual fact, it is our belief based on the law that you are married. Now, you will now have to come back and start the process of filing I-130 petition all over again. So at the end of the day, the time that you are trying to save, you may not be able to save the time. You may actually end up prolonging the time. So I pray your decision does not become Israelite journey. So that is why one of the reasons why we are doing this podcast, to let people know, so that you don't assume certain things. The fact that you hear or somebody told you that, "Oh, fiancé visa is faster," does not necessarily mean that it is faster. And like I said, fiancé visa is a non-immigrant visa. And because it's a non-immigrant visa, it can be denied. Unlike an immigrant visa, both of them can be returned to USCIS, but fiancé visa, because it is only valid for 90 days. When a fiancé visa is approved, the approval is only valid for 90 days. So if you go through that process and then the embassy decides not to issue the visa and return it to the US embassy, by the time they return it, if that 90 days has expired, which I can tell you with certainty that there is no way that process can be completed and the application returned to USCIS all within 90 days. It is practically impossible. So by the time they return it to USCIS, the 90 days will have expired. And USCIS is not going to do anything about it. They are going to just close the case. Whereas in the case of I-130 petition, even if the embassy have a legitimate reason to believe that you are not eligible for that benefit, they return the approval to USCIS with their recommendation. Now, because it's an immigrant visa, because it's a family petition, USCIS will send a letter to the petitioner and they will list whatever reason that was provided by the embassy for them to revoke the approval, and then give the petitioner an option. They will give the petitioner the benefit to respond to those allegations. And I can tell you, in my practice, ever since we have been receiving any kind of a recommendation from the embassy to USCIS to revoke applications, whenever the petitioner is given 30 days to respond to the issue of the embassy, I can tell you that 99.9% of the time, we have gotten USCIS to revalidate the approval and send it back to the embassy. So the USCIS, once we respond, USCIS will evaluate our response and compare it to the recommendation of the embassy. And like I said, 99.9% of the time in our own office here, the USCIS will send it back to the embassy and tell them that, well, thank you for your observation. We've noted what your concern was. We have considered it, but we are standing by our approval. We have seen that 99.9% of the time. So these are some of the benefits of going for I-130 petition versus going for fiancé visa. Because in the case of fiancé visa, you don't have all these benefits. Even if they deny it, in some cases, you may not even know the reason. Because, like I said, the embassy may not tell you what the issue is. They may just send it back to USCIS with their recommendation for revocation. And because the 90 days will have expired, the USCIS will not even tell you, because they are not even going to communicate with you. They will just close the case. So you may not even know what the problem is. So those are some of the disadvantages. But of course, does it have its advantage? Yes, it saves a few months in the processing time, which of course, in some cases, it may end up giving you more time. Now, I see that questions have been coming in, so let me just start answering the questions. To get married, that application is not approvable. Now, that brings up, if your fiancé have a child, of course, before marriage, he apply for K2 visa. Now, the reason I want to address this thing is that there is another thing called K3 visa. Now, what is the difference between K3 and K1? There is also K4. K4 is the dependent of K3. Now, let me tell you the difference between K1 and K3. K1 is a fiancé of a US citizen. K3 requires that the petitioner and the fiancé must be married. So they must be married. I-130 petition must be filed. But if you now believe that you are so much in a hurry, you cannot wait for the I-130 to be adjudicated, then you can file I-129F again, this time under K3 status. Now, If the K3 is approved, it will be forwarded to the National Visa Center and be treated in the same speed as a fiancé visa. But it's not a fiancé visa because you are already married and I-130 is pending. However, if before K1 visa is issued, if the I-130 is approved, which is what brought my attention from this question, if the I-130 is approved before the K visa is issued, that K visa will be automatically denied. Now they have to process the I-130 that was approved. So, very important. So going back to this question, if I get married after filing for fiancé visa, can I convert my petition to that of an alien relative? No, you cannot. You have to file a separate I-130 petition. Again, before I go further, because this question keeps giving me some other things that I need to share. Petition is approved while your K3 is pending. If your fiancé or now your spouse, if your spouse has a child who is under 21, that child cannot benefit from that approved I-130. I want to be very clear, and I want my readers to listeners to listen to me carefully so that there is no confusion. When you apply for a K visa, either K1 or a K3, K1 means fiancé. If you get K1 visa, that child will get K2 visa. Now, if you file I-130 petition and then apply for K3, if your spouse get a K3 visa, your spouse's child will get K4 visa. However, if the I-130 is approved before K3 visa is issued, your fiancé's child will not benefit from that I-130. So you will have to file, not fiancé this time, I'm mixing it up. Your spouse's child will not benefit from the I-130 approval. So that means that you will have to file a separate petition for that spouse. So if the I-130 that you file for your spouse has already been approved and is already with the National Visa Center, now you are going to have to start the process all over again for the child of your spouse. So these are some of the technicalities involved in this thing, and that is one of the reasons, in my opinion, why it is always better to just marry your spouse, follow the normal I-130 process. Because at the end of the day, let's say you marry somebody who has 2 kids, or you marry somebody who has 2 kids, and you file K3 visa. If your K3 visa is pending and then the I-130 is approved, now those 2 kids, they cannot benefit from the I-130 approval. You now have to start the process all over again. So why not just do it right? Get married to your fiancé. If your fiancé have children, submit I-130 for each one of them individually so that these things will be approved together and be processed together. Simple. The next question. A few years ago, I was removed from the US, but my fiancé, a US citizen, still resides in the US. Will I be able to gain entry into the US with a K1 Fiancé Visa? Well, this is not a yes or no answer because the writer of this question have not provided the reason for the removal. So we don't know whether there is a ground of inadmissibility that requires you to overcome. So this is I can't say yes or no. But the truth of the matter is it depends on the reason why you are removed. If you are removed simply because of overstay or minor immigration violation, it is better to get married to your spouse so that after marriage, even if you are found inadmissible, you may be able to apply for waiver of grounds of inadmissibility, assuming that the reason for your deportation is waivable. That's why I said this question is not very clear. I don't have enough information because it is not every ground of removal that is waivable. But if it is waivable, yes, you can come back in, but fiancé may be a difficult part. The next question. Does my fiancé have to earn a certain amount of money for us to apply for a K1 Fiancé Visa? What about for I-130? Well, money has nothing to do with either I-129 or I-130. However, if what is approved is I-130, along the process, when you get to the National Visa Center stage, you will need to submit IA-64, affidavit of support, in order for the immigrant visa to be approved. On the other hand, in the case of a fiancé visa, you will need to submit I-134. It is also affidavit of support, but affidavit of support for non-immigrants. The next question. My fiancé passed away prior to me receiving my K1 Fiancé Visa. What is going to happen to that petition? Well, that petition cannot survive because fiancé visa is a conditional visa, and the condition is that upon entry into the United States, you must be married within 90 days. So if the fiancé is already dead, there is nobody you can be married to. So that petition would die a natural death. The next question. Does an approved K1 Fiancé Visa mean I can work in the US? Well, if you come in with a fiancé visa, you will be stamped at the port of entry with a fiancé status. That status will authorize you to be able to work in the US for up to 90 days. Now, within the 90 days, you are required to get married. And once you get married, you can now submit application for adjustment of status and also apply for employment authorization in order to keep working. But if you do not get married within 90 days, after 90 days, your authorization to work will cease. From that moment, of course, if you continue to work, you are now working illegally. The next question. Can I file for K1 Fiancé Visa if I have never met my fiancé in person? Generally, no. However, there are a few exceptions. If you can establish that meeting your fiancé in person is contrary to your culture or contrary to a well-established religious belief, the physical meeting may be waived, but generally it is a requirement that you must have met your fiancé in person within the last 2 years from the date of filing the application. But if you can establish that there is a religious ground why you are not allowed to meet with this person, for example, if meeting with the person will cause you to be intimate, which is not permitted by your religious belief, you can provide that evidence. But again, this time is going to be at the discretion of USCIS whether to waive it or not. And of course, remember that fiancé visa has to be processed through the embassy, and the consular officers who are working in your home country, they are familiar with all these cultures that you are going to be referring to. So if they determine that that culture is not widely accepted or widely known, they may not approve the application. So it's a risk if you decide to go that route. But generally, the law requires that you must have met in person within the last 2 years from the date of submission of the application. The next question. My fiancé is a permanent resident. Can they file fiancé visa for me, or will it be better to get a spousal petition? Well, a permanent resident cannot petition for a fiancé. That is very, you will notice that in all these podcasts, I've been referring to US citizen, US citizen, US citizen. This is not one of those things that a permanent resident can do. There are several differences between what a US citizen can do and what a permanent resident can do. Fiancé visa is one of those things that a permanent resident cannot do. A permanent resident cannot petition for parents. A permanent resident cannot petition for fiancé. A permanent resident cannot petition for sibling. A permanent resident cannot petition for married children. So there are so many things that a permanent resident cannot do. This is one of them. So a permanent resident cannot petition for a fiancé. How long do you have to be together to get a fiancé visa? No, you don't have to be together. You just have to show that you have met in person in the last 2 years. Of course, if you are a US citizen, immigration knows that you are living here. And of course, your fiancé is living in a foreign. Have a fiancé you met physically this year 2024, and then submit a fiancé visa application for that person. So there is no requirement that you must have met for a certain number of days or years or months. No, there is no such requirement. The only thing is that you must have proposed marriage to this person for that person to qualify as a fiancé, because there is a difference between a fiancé and a girlfriend or boyfriend. They are not the same thing. So if this person is your boyfriend, no, he will not qualify. If this person is your girlfriend, no, she will not qualify. In order to be eligible, you must have proposed marriage, or the fiancé must have proposed marriage to you. One of you must have proposed marriage to each other in order to be eligible for a fiancé visa. The next question. If I came in on a fiancé visa and did get married within the 90 days, can I still get married after and then have my spouse file I-130? No, you don't need to get married twice. If you come in on a fiancé visa and you get married within the 90 days, all you need is just to apply for adjustment of status. You don't need to remarry. That one marriage is enough.
Sorry, it meant to say didn't. Sorry, typo.
Okay.
Did not.
Did not get married
Did not.
within the 90 days. Oh, okay. Okay, so let me reread the question to be sure I got it correctly. Okay. If I came in on a fiancé visa and did not get married within the 90 days, can I still get married after and then have my spouse file I-130? Is that the right question? Okay. Yes, the answer is yes. You can still get married. However, you have to, when the I-130 petition is filed, you will have to explain why you did not get married within the 90 days. But yes, you can still do it. Between the expiration of the 90 days and the time that you get married, or the time that you file the I-130 petition, the only problem is you will be out of status. And at that stage, you will not be able to legally work in the United States. But yes, it can be cured upon your marriage and upon application for adjustment of status, probably file concurrently with I-130 petition. Yeah, you can cure the problem. The problem can be cured. So the next question: what happens if I came in on a fiancé visa and don't get married? Yeah, I just answered that. You'll be out of status. You'll become illegal alien. That's it. You will not be able to do anything. And like I said, you cannot marry somebody else. If your fiancé failed to get married to you, you cannot marry somebody else. If you marry somebody else, you cannot adjust in the United States. You will have to go back to your home country and start the process all over again. But you cannot get married. to somebody else in the U.S. It is only the fiancé who filed the petition for you that can get you green card in the U.S. If you don't marry to that person, you'll be out of status. The only thing you can do, you are only allowed to go back to your country. You are not allowed to adjust status. The next question. I read online that a fiancé visa can be denied if there is a lack of common background, such as religion, ethnicity, culture, or education. Is that true? No, that is not true. That is not true. I mean, there are so many fake information online. There are so many misleading information online. I mean, America is a country that you have the freedom of religion. For those who have seen American Constitution before, in fact, if you are a naturalized citizen, one of the questions during citizenship is what the Constitution say about religion. In the United States, you can choose to practice whatever you like, any religion you want, and you may also choose not to practice any religion at all. So religious belief cannot be a ground for adjudication of any immigration benefit. It cannot. It is not possible. So this is fake news. In fact, I've handled a case where USCIS requested my client to submit a DNA test, and I responded that my client's religious belief does not permit DNA. Initially, USCIS denied the case on that ground. Of course, I filed an appeal, and immediately I filed an appeal. They reversed course and sent a motion asking the Board of Immigration Appeal to return the case, and then they subsequently approved it, because you cannot force somebody in the United States to believe one thing or the other. Anybody can choose to believe anything, and anybody can choose not to believe anything at all. So that cannot be a basis for the petition be denied. If I met my fiancé from an online website that pairs us citizens with foreigners wanting to get married, what about an I-130 if I get married? Well, for anybody seeking immigration benefit, the burden of proof is on the applicant. So if you are the one applying for a fiancé visa, you have the responsibility, you have the burden to show that your fiancé is eligible for that benefit. And one of the requirements for a fiancé visa is that you must show that the relationship is bona fide, that the relationship is legit. How you met is immaterial. How you met does not show one way or the other whether your relationship is legit or not. How you met is immaterial. The most important thing is for you to show that this is a legitimate relationship. Yes, the initial conversation may have started through online, but how did it develop? I mean, you can't meet somebody online and then the next thing you propose marriage. No. From the time you met online, how did your relationship develop to the extent of proposal? How long did you date before you even talk about proposal? So, was there any financial incentive for the proposal? Have you even met in person after your initial online meeting? I mean, there are so many things that you have to show. And like I said, the burden is on the applicant or the petitioner to show that he or she is eligible for the benefit being sought. So, the fact that you met online is completely immaterial. It is what happened after your meeting. How does it transition from online meeting to dating to proposal? That is the most important thing. And of course, immigration, or even in some cases the embassy, may ask for proof of communication, proof of relationship. So it is only, look at that. So it is only when you provide all this evidence that your application can be denied. So it is not how you met. So the fact that you met online is.
Okay, go ahead, we're back.
So are we back online now?
Yes, yes.
Okay. Apology for the short interruption. We have some technical glitch here. I believe everything is okay now. So can people hear me now? Do you know?
Yes.
Okay. I know I was addressing a particular question before the interruption. Okay, yeah, it was the B part of that question. What about an I-130 petition? So I was explaining that whether you file a fiancé visa or you file an I-130 petition, the requirements are the same in that you have to show that the relationship is bona fide. So how you met, the fact that you met online does not mean that your relationship is not bona fide. But how you met is only the beginning of the relationship. What did you do after? So how did the relationship transition from online meeting to physical meeting to dating to proposal and then to marriage? So you still have to show in all cases, whether it is fiancé or I-130 petition, you still have to show that the marriage was entered into in good faith and that the relationship is legit. That is a mandatory requirement. Well, it doesn't matter whether you file fiancé petition or I-130 petition. That seems to be the last question I have here. Okay, I'll be waiting. So today we are discussing which is better, to file a fiancé visa or to file I-130 petition. And for those who join us from the beginning, you will have explained all the series of benefits of each one of them. To file as a fiancé, you may think it has some advantages which may actually be there, maybe a couple of months in processing time, but that may also backfire. It may go wrong, and at the end of the day, what you intend to achieve by filing a fiancé visa may actually create more problem. So there are benefits of filing fiancé visas, and there are also benefits of filing I-130 petition. It depends on which side of the aisle you are in. If I'm a U.S. citizen wishing to bring in a spouse, one of the things I will consider, it depends on how much do you know this spouse. Because people have brought in spouses from foreign countries, and then those people have come into the US within a year or two, they change completely. Condition process if you file for fiancé visa. No, there is no way, because fiancé visa is not I-130. And the law is that from the date that your green card is approved, if your marriage, not your relationship, if your marriage is less than 2 years, you get a conditional green card. So it doesn't matter whether you come in as a fiancé or you come in as a spouse. What determines whether you get a conditional green card or not is the date of your marriage. Remember, for a fiancé, you can't even get married until you enter the US. So your marriage does not start counting until after the marriage. So the 2 years does not start counting until after the marriage. So at the end of the day, and then you go through that process on the day, that will now be on the day you enter the US, not on the date of marriage. Not on the date of marriage, yeah. On the date you enter the US, if your marriage is less than 2 years, you still get conditional green card. But on the day you enter the US, if your marriage has been 2 years old, then you get 10-year green card. So if you want to avoid it, it is just better to go through regular marriage petition process. The next question: can USCIS check my social media to see if we are married? My fiancé is Vietnamese and we had a religious tea ceremony. We did not fill any paperwork to be legally married, but I posted it online. To to my private social, I posted it to my private social media. I'm scared USCIS will find out. Is it better to try and get a Vietnamese marriage certificate? I have no clue how to do that and go for I-130. Well, the first thing I'm going to tell whoever sent this question, it depends on the Vietnamese culture. If Vietnamese culture recognize common law marriage, or if what you posted as a tea, where is that? What you mentioned as a tea ceremony, if it constitutes a form of marriage under that culture, yes, the fiancé visa will be denied. Because even if USCI did not catch it, the US Embassy in Vietnamese is going to catch it. In Vietnam, sorry, is going to catch it. So it is important. It depends on what that tea culture, what it means. Is it tea culture? I'm looking for the thing I can't see.
Religious tea ceremony.
Yeah, so it depends on what that tea ceremony means. Like I said, when I explained this, I used the Nigerian culture of introduction and engagement. So if the tea ceremony under Vietnamese culture, if it means marriage, yes, the fiancé visa will be denied. But if it does not, it may not impact it. But to answer your question, can USCIS check your social media? Yes, they will. And in addition, even if they don't, because you are required to show evidence of relationship, you are required to show evidence that your relationship is in good faith. So you are still going to have to provide pictures of everything you have done together. And the embassy, like I said, because they are local, you are going to go to the embassy in Vietnam. So they are local. They know what the local culture is. So if the local culture consider this relationship as married, then that fiancé visa application is going to be denied. So if you know that this is a problem, just travel to Vietnam, meet your fiancé in person, and get married under their legal way of getting married in Vietnam, and then come back and submit I-130 petition. That would be my advice in this situation. That would be my advice in this situation. Every culture is different, but the beauty of this is that the final adjudication is going to be conducted by the US Embassy in the home country, in your fiancé's home country. In this case, that will be Vietnam. And because they are familiar with the culture, they can easily know. And of course, USCIS also have access to your social media account. Even the embassy, they have access to your social media account. So, and I believe we have done something. We did a topic last week about how the tools. Yeah, so whoever sent this question can go back and watch our episode last week. We discussed how USCI, some of the tools they use to adjudicate applications and petitions. So you will see that definitely they can see your social media posting. So, am I expecting any additional questions? Okay, so today we discussed which one is better, to file a fiancé visa or to get married and file I-130 petition. So we have seen that each one of them have their benefits and they have their disadvantages. And we have discussed that extensively. So if there are no additional questions, I believe that we'll be hanging up today. We hope to see you again next week. But remember, invite your family, friends, your colleagues. You will know that on this program, we provide valuable information every week. So the only thing you can do to show appreciation is to spread the news, because the more people benefit from this, the less people who are making avoidable mistakes. And that is the only thing we set out to avoid, to ensure that people do not make avoidable errors. So we hope to see you again next week. Remember to join us every week. You can also follow us on social media. We are on Reel, we are on TikTok, we are on Instagram. We provide daily information, short reel clips. We provide daily information on those other platforms. So see you again next week.